Today's lesson is race in school admissions, and specifically the long debate we've had in the federal courts over affirmative action in higher education. This is a dispute that has arisen many times over the last 50 years or so, and has resulted in several famous court cases, and one that's about to happen. And I want to kind of tell you about the history of it and let you know about the court case that's going to be heard this year, and that the Supreme Court will be making a very interesting decision on. So the question to consider is, can colleges and universities use race as a factor in deciding which student applicants to accept or reject? And do these policies, these affirmative action policies, violate the 14th Amendment and or the Civil Rights Act of 1964? And I'll talk to you about each of those so you see what I mean. So first, the 14th Amendment says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So for the 14th Amendment, the key phrase is equal protection of the laws. Do affirmative action policies, which distinguish among applicants for college based on their race or ethnicity, do they violate this guarantee of equal protection of the laws? Now, I mentioned equal protection last time, talking about Brown versus Board of Education. So if you remember, Brown versus Board of Education was this case that the Supreme Court decided in 1954. It was about Linda Brown and other plaintiffs, school children who were segregated because of their race. And the question there was, did the segregation of public school based solely on race violate the Equal Protection Clause of the 14th Amendment? So, remember that I said that the lower courts relied on Plessy versus Ferguson and upheld the segregation policies. Plessy versus Ferguson was the 1896 case that came up with the separate but equal doctrine. But then in the Supreme Court decision, the court unanimously ruled that separate but equal was no longer valid, and that segregation in public schools violated the Equal Protection Clause. So that was a hugely important decision, right, regarding race and public schools, public education. And then along comes, 10 years later, the Civil Rights Act of 1964. And so the question I had was, does affirmative action violate the Equal Protection Clause and or this act? I want to tell you a little bit about this act so you can see what the issue is here. So the Civil Rights Act said, Title II of it says, all persons shall be entitled to the full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations of any place of public accommodation, as defined in this section, without discrimination or segregation on the ground of race, color, religion, or national origin. Any inn, hotel, motel, or other establishment which provides lodging to transient guests. Any restaurant, cafeteria, lunchroom, lunch counter, soda fountain, or gasoline station. Any motion picture house, theater, concert hall, sports arena, stadium, or other place of exhibition or entertainment. So these are private businesses, but of public accommodation that serve the public, right? And this says it's now illegal to racially discriminate among your clients, right? Your customers, in places of public accommodation. So that's a little bit different than schools, but if we go ahead, Title IV of the Act talks about busing in schools. Nothing herein shall empower any official or court of the United States to issue any order seeking to achieve a racial balance in any school by requiring the transportation of pupils or students from one school to another or one school district to another in order to achieve such racial balance, or otherwise enlarge the existing power of the court to ensure compliance with constitutional standards. So Title IV seems to be saying that nothing in the Act is meant to imply that schools have to bus students from one district to another or one school to another in order to racially balance the schools. So they seem to be prohibited from taking race into account in that sense. This is the key part, Title VI, for us. It says, no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. One of the cases I'm going to talk to you about today involves Harvard University, which is a private school, not a government school. And the allegation is going to be, in part, that Title VI is being violated because Harvard receives federal funding and yet will allegedly be using affirmative action programs that discriminate against students on the basis of race. You'll see what I mean by that when I get to it. Okay, Swan versus Charlotte Mecklenburg was an important Supreme Court case in 1971. Remember, I just read to you a part of the Civil Rights Act that said that you cannot bus students on the basis of race in order to achieve racial diversity in the schools. So this question involved a school district that was doing exactly that. And so the question was, can federal courts mandate busing programs to integrate schools as a remedy for past state-imposed segregation? The basic background for this case is, after the Supreme Court's decision in Brown versus Board of Education, very little progress had been made in desegregating some public schools. In the Charlotte-Mecklenburg system in North Carolina, approximately 14,000 black students attended schools that were either totally black or more than 99% black. So a federal court there ordered the use of mandatory busing to achieve a racial balance in the schools. The court said you have to bus the black kids to white schools and the white kids to black schools to mix the schools. But that seemed to contradict the language of the Civil Rights Act that I just read to you, which says you can't do that. So the court had to decide. The court said unanimously that the school district's order of busing to achieve racial balance was okay. That it had the power to do that despite the language of the Civil Rights Act. So for us, the key, we're going to be talking about affirmative action and admissions policies. The key is they could be cognizant of the race of students, right? They could take that into account in deciding what to do with them. We'll skip this one. Right. There we go. Now we come to the first major case involving actual affirmative action programs and admissions. So did the University of California, is the question, violate the 14th Amendment's Equal Protection Clause in the Civil Rights Act of 1964 by practicing an affirmative action policy that reserved a specific number of places for minorities, resulting in the rejection of Alan Backey's application for admission to its medical school? Here are the facts of the case. Alan Backey was a 35-year-old white man who twice applied for admission to the University of California Medical School at Davis. He was rejected both times. Meanwhile, the school reserved 16 places in each entering class out of 100 for minorities as part of the university's affirmative action program. And his GPA and his test scores were higher than any of the minority students that were admitted. So he contended that he was being excluded solely on the basis of his race, and that this violated his equal protection rights, and it also violated the Civil Rights Act. That's his argument. Now, Bakke sued in 1974 in the Superior Court of California in Yolo County. So he sued in a California court, a state court. He sought an order admitting him on the ground that the special admissions programs for minorities violated the United States and California constitutions and Title VI of the Civil Rights Act of 1964. UC Davis requested that the judge find that the program was constitutional and legal, and argued that Bakke would not have been admitted even if there had been no seats set aside for minorities. I don't know what they mean by that. Maybe there were other white candidates that were gotten in ahead of him. Maybe that's what they mean. So in November of 1974, the judge in the Superior Court, in the California court, found the program unconstitutional and in violation of Title VI, and wrote, "No race or ethnic group should ever be granted privileges or immunities not given to every other race." The judge ordered the medical school to disregard race as a factor and to reconsider Bakke's application under a race-free system. Both parties appealed. The medical school appealed because they wanted the whole decision overturned. They wanted to continue having their affirmative action program. Bakke appealed because the judge didn't actually order him admitted to the school, and he wanted that to happen. So they appealed to a higher court. So the Supreme Court of California was next. The case was argued before the California Supreme Court in 1976. The California Supreme Court was considered a very liberal court, but it surprised observers by ruling in favor of Bakke, or upholding the lower court's decision 6-1. The judge in the majority, Stanley Mosk, wrote the decision. He said, "No applicant may be rejected because of his race in favor of another who is less qualified, as measured by standards as applied without regard to race." So the majority decision, you have to use standards that don't take race into account. One judge dissented. He said it was unrealistic to expect medical schools to diversify without this affirmative action program. He said it is a cruel hoax to deny minorities participation in the medical profession on the basis of such fanciful speculation. So, next, the university, they've now lost at the California Superior Court, they've now lost the California Supreme Court. Now they appeal to the United States Supreme Court. First, they ask that the order requiring Bakke's admission be stayed, and a Supreme Court justice named William Rehnquist grants the stay, so Bakke still doesn't get to go to medical school. It's been now 2 years since he was initially rejected, but they're going to wait on the outcome of the Supreme Court's decision. So the case was argued in front of the U.S. Supreme Court in 1977, in October. The university argued that Bakke had been rejected because he was unqualified. Bakke's lawyer argued that his rights under the 14th Amendment to equal protection of the laws had been violated. 58 amicus curiae briefs were filed. These are friend of the court briefs. I mentioned them a few days ago. These are briefs where interested parties submit an essay called a brief to the court, trying to persuade it to make a certain decision. The fact that so many briefs were filed suggests how interested other people were in the outcome of this case. Many people were interested in the case. And that was more briefs, more friend of the court briefs than the Supreme Court had gotten in any other case up to that point. That was the record. The United States filed a brief arguing that the Supreme Court should uphold the medical school's affirmative action program, saying that these programs were necessary to make up for past discrimination, but the U.S. Department of Justice opposed quotas or rigid set-asides. And remember, the medical school did have a quota. It said 16 seats are reserved for minorities. Right? They don't have to compete with white students with the majority. They're just reserved. And so the Department of Justice of the United States did oppose that. This is an interesting memorandum from Thurgood Marshall to his colleagues on the court. He sent this as they were discussing the case among each other, and he was vigorously in favor of ruling for the affirmative action policy that the medical school had. He says here some interesting things. He says, "I repeat for next to the last time, the decision in this case depends on whether you consider the action of the regents as admitting certain students or as excluding certain other students. If you view the program as admitting qualified students who, because of this nation's sorry history of racial discrimination, have academic records that prevent them from effectively competing for medical school, then this is affirmative action to remove the vestiges of slavery and state-imposed segregation by root and branch. If you view the program as excluding students, it is a program of quotas, which violates the principle that the Constitution is colorblind. If only the principle of colorblindness had been accepted by the majority in Plessy in 1896, we would not be faced with this problem in 1978. We must remember, however, that this principle appeared only in dissent. In the 60 years from Plessy to Brown, ours was a nation where, by law, individuals could be given special treatment based on race." His argument, basically, was that because of slavery and segregation, black students needed special treatment to overcome that legacy, to overcome that history. And he was disappointed that a majority of his colleagues didn't agree with him. So the case had a very unusual and interesting result. There was no single majority opinion. Almost always, at least 5 judges agree on something, and that's the majority opinion, and often more, maybe all 9 of them. In this case, you had shifting majorities. So 4 justices plus Lewis Powell said that the racial quota system, the set aside of 16 seats, violated the Civil Rights Act and the Equal Protection Clause. So he struck that down. He said you can't have a rigid quota. You can't say we're going to set aside X number of seats for black students, Hispanic students, minorities, whatever, and do it that way. So that was struck down. Another 4 justices, the other side of the court, plus Powell again, said that you can use race as a criterion in admissions decisions as long as it's not the sole factor. So if you use a whole bunch of factors like race, extracurriculars, grades, test scores, and it's one of many factors, then it's okay. But it can't be a rigid quota system, and it can't be the only factor. So there was a majority for striking down the quotas, but there was a majority of 5 with Powell at the center for each of them for allowing affirmative action programs that used race as one factor among many. So Powell ordered the medical school to admit Bakke, and he concluded that the rigid use of racial quotas violated the Equal Protection Clause and the Civil Rights Act, but that the use of race as one of several admission criteria was permissible. And essentially, that's where the law stands today. In a sense, that's where we're at, 50 years later almost. There was another major case called Grutter versus Bollinger in 2003. This involved Michigan Law School. In 1997, Barbara Grutter, a white resident of Michigan, with a 3.8 undergraduate GPA and an LSAT score of 161, which is very, very high, applied to the Michigan Law School. She was denied admission. The law school admitted that it uses race as a factor in making admissions decisions and said it serves a compelling interest in achieving diversity among its student body. So the Supreme Court had to decide, is that okay? Sandra Day O'Connor wrote the decision. It was a narrow decision, 5-4. And she held that the Equal Protection Clause does not prohibit the law school's use of race in admissions decisions to further a compelling interest in obtaining the educational benefits that flow from a diverse student body. So the school had an interest, a compelling interest, and this is legal language. In order to discriminate on race and get away with it, the school had to say it had a compelling interest in something that necessitated using race as a factor, right? If you're going to use race as a factor, it can't be arbitrary. It can't be because you don't like white people or Asian people or whatever it might be. There has to be a compelling interest that's a legitimate interest. And the interest was diversity. The school said, our school is better if it is racially diverse, if there are more Black and Hispanic students. And therefore, we have a compelling interest in using race in order to achieve that, right, through our admissions process. And that's what Sandra Day O'Connor and 4 other judges agreed to. They said that passes constitutional standards. And they said the law school conducted a highly individualized review of each applicant. No acceptance or rejection was based automatically on a variable such as race, and this process ensured that all factors that may contribute to diversity were meaningfully considered alongside race. A few years later, you had another famous decision. This was Fisher versus University of Texas. Abigail Fisher, a white female, applied for admission to the University of Texas but was denied. She did not qualify for Texas's top 10% plan, which guarantees admission to the top 10% of every in-state graduating high school class. For the remaining spots, the university considered many factors, including race. Fisher argued that the use of race as a consideration in the admissions process violated the Equal Protection Clause, and the question was whether or not the court would agree. Here I have a picture actually of the guy who wrote the dissent, Clarence Thomas. First, let me get to what the school said, what the majority said. The majority said that the use of race as a consideration of the admissions process did not violate the Equal Protection Clause of the 14th Amendment. So like Bakke, like Grutter v. Bollinger, in the Fisher case, the court is still saying affirmative action is okay if it uses race as one factor among many in deciding whether or not to let somebody in. They said educational diversity is a compelling interest if it is expressed as a concrete and precise goal that is neither a quota of minority students nor an amorphous idea of diversity. The University of Texas plan was narrowly tailored to serve this compelling interest, and there were no other available and workable alternatives for doing so. Justice Clarence Thomas wrote in the dissent that the Equal Protection Clause of the 14th Amendment categorically prohibits the use of race as a consideration in a higher education admissions process. His opinion, in other words, was you can't use race as a factor, period. The Constitution prohibits you from considering someone's race when you're deciding whether or not to let them come to school. And that brings us to the case that's ongoing now. So this is a very interesting case that's still in the works. It's been winding its way up through the courts for several years, and it's now waiting to be argued before the Supreme Court. And what will be interesting is to see if the court continues to uphold these affirmative action programs or goes with what Clarence Thomas said, which is you can't use affirmative action, you can't use race-conscious policies. So this is called Students for Fair Admissions Incorporated versus Harvard, right? President and Fellows of Harvard College. In November 2014, a nonprofit, you can ignore that date, I think 2019. I put that date there because at the time I wrote this, it was still a circuit court case, but now it's going to be a Supreme Court case, so it's going to be 2022 or 2023. In November 2014, a nonprofit membership group called Students for Fair Admissions filed a lawsuit against Harvard University. The suit alleged that Harvard discriminated against Asian American applicants and altered admission scores in order to continue to maintain a racially balanced student body. The share of Asians at Harvard had peaked at over 20% in 1993, then had declined and thereafter remained roughly constant at a level 3 to 5 percentage points lower. Even though the Asian American population has more than doubled since 1993 and also has the number of highly qualified Asian American applicants. Make sure you understand what I'm saying there. In 1993, around 20% of Harvard students were Asian, and that's the peak. And then it went down into the teens, around 17, 18, 15 to 17%, and it has stayed there ever since. So for the last 30 years, every year, about 15 to 17% of Harvard students are Asian. But the number of Asians in America has doubled since then, and the number of Asian applicants to Harvard has gone up, let's say, maybe not doubled, but gone up, and yet the percentage is the same. So that's just one factor to consider. Asians have the lowest acceptance rate at Ivy League universities for each SAT test score bracket. I'll give you the numbers, what I mean by there. Having to score on average approximately 140 points higher than a white student, 270 points higher than a Hispanic student, and 450 points higher than a black student. So they looked at the numbers, and in order to get to Harvard or Yale or Princeton, an Asian, let's say, whatever, you have a black student, you have a Hispanic student, you have a white student, you have an Asian student, and they all want to go to Harvard, right? So the black student gets whatever score on the SATs, right? In order for the, I'm not explaining this word, and the Hispanic student gets Y, and the white student gets Z. So the Asian student has to get 450 points higher than the black student to have the same chance of being accepted, right? The same chance. Has to get 270 points higher than the, my X, Y, and Z is silly. Erase that. So they have to get 450 points higher than the black student, 270 points higher than the Hispanic student, and 140 points higher than the white student.
This is now?
This is over the last 20 or 30 years. Yeah, this is now. So the question was, why do they have to score so much higher on the tests in order to have the same result, in order to get into, be accepted into the schools? And that's going to be a part of the lawsuit. And it's suggested to the Asian students who are suing is that they must be discriminating against us. They must be holding us to a higher standard than they hold everybody else to. So, one of the reasons why it was so much harder for them to get in may have been, according to the Asian lawsuit, this is their view, It came out during the lawsuit, during the trial, it came out that they were scoring much lower than the other races in personal scores or personality scores. In other words, applicants would get graded on their grades, on their test scores. They would get evaluated on whether or not they had extracurricular activities, like they were good at sports, or they were good at music, or something like that. And then they would also get an evaluation on their personality. And, shockingly, the Asians were being scored really low on their personalities. The black applicants were scoring the highest. The Hispanic applicants the second highest. The white applicants the third highest. The Asians at the very bottom. So supposedly, according to Harvard, the reason it was so much harder for the Asians to get into school is they had worse personalities. They had better test scores, better grades, and actually they had better extracurricular activities. They were more likely to be musically talented and that sort of thing. But because they scored so low on the personality evaluations, they were having trouble getting in. Now the Asians said, that's just a code for discrimination. Right? That's just a number they assign us so that we can't go. And Harvard, of course, disagreed. I messed up earlier. So in 2019, they have the trial at the United States District Court in front of Judge Allison Burroughs. And Judge Burroughs ruled in favor of Harvard. She said their policies did not unduly discriminate against Asian Americans. She said there's no evidence of any racial animus whatsoever, and no evidence that any admission decision was negatively affected by Asian American identity. So no evidence, I guess, that Harvard doesn't like Asian people and was doing this because it wanted to hurt them. So the plaintiffs, the Asian student group, appealed to the United States Court of Appeals for the First Circuit, and they heard arguments in 2020. So that's the second stage. The United States Court of Appeals, and this was in the First Circuit. And at this stage, you're not re-arguing the facts of the case. There are no more witnesses, there's no more testimony. They're just deciding, did the judge get the law correct? Right? Did she make any legal errors in her decision? And the court said no. The court upheld Judge Burroughs and said that she had not erred in her ruling and in her findings. Now, it's interesting. This will give you a glimpse into how politics plays a role in all these things. In 2019 and 2020, the president was Donald Trump. So you had a Republican administration and a Republican administration running the Department of Justice. So the Justice Department filed a friend of the court brief arguing that Harvard unlawfully discriminates against Asian Americans by racially profiling students throughout the admissions process. And so they wanted a ruling against Harvard. So the Trump administration was pro the Asian students in both of these cases. Also, under President Trump, the Department of Justice sued Yale University, different Ivy League school, arguing that its admissions policies discriminated against Asians. So in other words, the administration said, we support the Asian students here, and we also think Yale is doing the same thing. And so they initiated their lawsuit against them. But in 2021, you had a new president come in, and a new administration, and this president supports affirmative action policies. So now that the case is before the Supreme Court, the administration has come out in favor of Harvard's policy and is urging the court to uphold it, like the lower courts did, right? And the new administration dropped the lawsuit against Yale. So Yale is no longer having to defend its policy. So that's where we are now. In 2021, the Asian Student Organization petitioned the Supreme Court to hear the appeal from the Court of Appeals. In January of 2022, the Supreme Court agreed to hear the case, and we think the Supreme Court will have arguments on the case this term, so in October or November. And sometime next summer, we'll know what they say. Maybe they'll agree, like they agreed in Bakke and Grutter and Fisher, to uphold the program, or maybe there will be a big change. There have been big changes in some other legal cases that were very controversial as well, so maybe this will be another one where the court changes its mind. We'll see.